Tom, hey, it's David. Man, we gotta talk about what's gone down over the past couple of days.
Yeah, what a win for righteousness.
So, is this the end of abortion in America?
Okay, Dave, overturning Roe is a monumental victory, but that doesn't mean that the practice of abortion just goes away.
What's that mean? I mean, like, for us, practically.
We'll talk about the details in just a minute, but first, let's talk about two other important wins for individual and religious liberty.
Oh, are you talking about the government withholding vouchers for Christian schools and, what was going on in New York, the concealed weapons thing?
So much is happening under this new Supreme Court brought about by President Trump's appointment of 3 new justices, which itself was a result of the actions and prayers of God's people.
Agreed. What do you want to hit first?
The first case that I want to talk about was a decision that was handed down on Tuesday. It's called Carson versus Mackin. In that case, the Supreme Court struck down a Maine law that excluded most religious private schools from a voucher program that is in place for secular schools. The decision was 6-3 in favor, and it's a huge victory for the principle that government may not discriminate on the basis of religion.
Wow, that's huge.
Next up is the case of the New York State Rifle and Pistol Association versus Bruin. This was a decision that came out on Thursday. In Bruin, the court struck down a New York law that made the ability for law-abiding citizens to obtain a concealed carry permit nearly impossible. The Supreme Court struck it down.
Thank God. Do you know what it includes?
In sum, the Bruin decision did a number of things. First, it made very clear that the Second Amendment's guarantee of the right to bear arms exists outside the home. It also recognized that the Second Amendment, like all other individual rights enshrined in the Bill of Rights, is a first-class right.
That's a big win for the people. I imagine the details are pretty hard to follow.
I don't always recommend people read Supreme Court cases. It's not the most exciting reading for a lot of people, but if anybody's interested, these cases are very approachable, and the historical discussions about the right to keep and bear arms is quite good and worth the read.
For sure. But honestly, I'm a little fuzzy on the legal side. What's all this mean, and what's our next step?
The case that came out on Friday that overturned Roe versus Wade, and another case called Casey versus Planned Parenthood, is the case of Dobbs versus Jackson Women's Health.
Okay, I'm listening.
The law at the center of this Dobbs case was a Mississippi statute that prohibited abortion after 15 weeks of pregnancy. Jackson Women's Health Organization is an abortion center in Mississippi, and it argued that there could not be a compromise. No compromise was possible regarding its statute, the statute at issue, and prior abortion precedent. That's Roe versus Wade and Casey. In other words, Roe and Casey either stood or fell based on how this case was framed. Ultimately, Roe and Casey have fallen.
Tom, do you realize, this is historic? I'm so proud of our generation for standing for the truth and making a significant change for the better. And everybody's talking about it. It's all over the news. My phone's been blown up. Can you explain what exactly it means to have overturned Roe? What do they mean when they're saying that?
Let me give you a little bit of background that will help contextualize the case and enable you to understand it a little bit better. First, the current Supreme Court case that really governs abortion law is this Casey versus Planned Parenthood case. That was a case that was decided after Roe versus Wade.
Wait, wasn't Roe versus Wade the first case to find a constitutional right to abortion?
Roe versus Wade was the first. The court found this right to abortion not in the text. As you all know, there's no text in the Constitution that mentions the right to abortion. What the court did in Roe was use a doctrine that the Supreme Court has used called substantive due process. Now, you may understand due process is the right that has to do with your process rights. So if you get arrested by the police, you have a right to be read Miranda warnings, you have a right to a lawyer, you have a right to confront your witnesses. Those are procedural rights.
What was the other one? Substantive?
Substantive rights are things like the First Amendment that say you have the right to free speech, the Fifth Amendment that gives you, or the Fourth Amendment that gives you the right to be free from searches and seizures, illegal searches and seizures, and things of that nature.
Okay, so what did the court find?
The court has found that because of certain process rules, there is substantive rights that emerge from that, and abortion was something that the court felt in Roe versus Wade was a right that was hidden within this due process right.
So what does the Dobbs case do?
The Dobbs case undoes all of that. The Dobbs court held, quote, the Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives.
That's why you said this case doesn't simply make abortion go away.
The Dobbs decision does not make abortion go away. What it does is it eliminates the view that the Constitution provides and enshrines a right to abortion. That quote that I just read to you. There is no right to abortion in the federal Constitution.
What you're saying is the people have been entrusted with the decision rather than the government?
That means the states are free to pass laws that regulate abortion. That also means they can have laws that permit it. But the point here, the key issue of freedom is, first of all, there is no fundamental right under the United States Constitution for an abortion. And number two, that the determination of what is proper policy is, a bunch of moral decisions and policy choices that the Supreme Court is not equipped to deal with, but that should be the proper province of states. And the court noted in its historical overview of what the laws were like in the United States involving abortion before Roe versus Wade, there is this telling quotation. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treatise. Indeed, abortion had long been a crime in every single state.
Man, that is wild. This should be a national holiday. It just makes so much more sense. I appreciate you taking the time, and honestly, I always appreciate how you explain this complicated legal jargon. Hey, if you don't mind, I think I'm going to share this with Strong Tower. Would that be cool?
Yeah, please do. I love Strong Tower and all the reports that I hear from you about what's happening over there in Casper. God's people need to be informed and prepared to make the next step. So I hope this helps.
It does. I love you, brother.
I love you too. We'll talk soon.